Malcolm Burrows, Principal of Dundas Lawyers. Dundas Lawyers is an award-winning corporate, technology and intellectual property law firm that also passionately litigates in these areas of practice. We have offices in Brisbane and the Gold Coast. Today I'll be briefly discussing the various grounds on which a patent may be revoked. In legal proceedings involving patent infringement, usually in the Federal Court of Australia, it's common for a respondent to go on the offensive and attempt to convince the court the patent in question is invalid and should never have been granted in the first place. So if proven, it necessarily follows that there can be no infringement. There's no one section of the Patents Act 1990 that specifically deals with invalidity, as we refer to it. In effect, invalidity is established by proving that the requirements for a valid patent, as required in Section 18 of the Patents Act, are not made out on the patent in question, or that there are other grounds, such as those contained in Section 40 and Section 138, which the patent does not comply with. So what specific grounds generally are available for seeking revocation of a patent? Some example grounds include, for example, that the patented invention lacks novelty. In the case of a standard patent, that the patented invention lacks an inventive step, or in the case of an innovation patent, that the patented invention lacks an innovative step. Further, the patented invention is not useful, that it does not do what the patentee promised it could do, or that the patented invention was secretly used in the patent area before the patent was sought. The patented invention might not be a method of manufacture, as defined within Section 6 of the Statute of Monopolies, which is a test that goes back decades, as evolved by case law. Alternatively, the patent was obtained by fraud, false suggestion or misrepresentation. Alternatively, the patent specification does not provide sufficient information and instruction for a person skilled in the field of the patent that relates to be able to perform the teachings of the patent and produce an invention falling within the claims of the patent. This is known as sufficiency. Alternatively, the patent fails to disclose the best method known to the patentee of performing the invention. And lastly, the patent's claims or claims are not clear and succinct and supported by a matter disclosed in the patent specification. Note this isn't a comprehensive list, however there are other grounds which may be considered and variations of these depending on the circumstances. In addition, various of these grounds overlap from a technical perspective. One of the usual things we encounter in a patent revocation matter is an initial concern along the lines of, well, this has been done before, or the patent doesn't work. Those are usually indicia, or what we call factors to take into account to consider the various grounds of invalidity, which may act as a quasi-defence to patent infringement. So many of the grounds for revocation involve complex analysis at a legal and technical level within the field of the invention described in the patent. Ultimately, however, it will be for the court to decide, with of course the assistance of expert evidence, that decides whether or not a patent is liable to be revoked. So if you believe there are grounds for a patent to be revoked, you should seek legal advice about how to achieve your goal, as the evidentiary requirements can be quite onerous. In addition, you need to have the involvement of a patent attorney who is skilled in the particular area of the invention. So if you're looking for an intellectual property law firm that's passionate about enforcing or defending your rights, please don't hesitate to call me on 3221 0013 for an obligation-free and confidential discussion. Thanks for watching.